The time is now approximately 12:52 p.m. We are now going back on the record.
Mr. Martin, in paragraph 24A, you list excerpts from the July 21st, 2014 broadcasts, and you've again read the complaint with regard to what you believe to be defamatory. Let me try it a different way. In that broadcast, did Mr. Villa say anything which he knew was false?
I don't know what Mr. Villa knew, Mr. Shea. I am alleging in the complaint that there is no factual basis for the claims that he made as are set forth in paragraph 24A of the complaint.
But he did set forth facts, not only in this interview, but other interviews to support his claims here, did he not?
I dispute your characterization of anything that Mr. Villa states as facts. They're not facts unless you know them. Mr. Villa doesn't know them. Therefore, he's acting in reckless disregard of truth and falsity.
Okay. So what did he say there which he knew to be false?
I'm saying exactly what I've just read from paragraph 24A. When he says that DA Jim Martin fixes these cases, that is made in reckless disregard of the truth because it's false.
Okay. But you have to show more than falsity.
We're not going to get into a legal argument here over the merits, the legal merits of the case with this witness. We're not doing that. We're not doing that.
Right.
We'll do that in our summary judgments.
May I complete my question before you object to it and go off the record?
Go ahead.
Right. You're going to have to prove actual malice, and you've already acknowledged that, correct?
Yeah, I believe that proof of actual malice, which can be proven, as I recall, by establishing that statements were made with reckless disregard for truth or falsity.
All right. Well,
Let's go off the video.
The time is now approximately 12:54 p.m. We are now going off the record. The time is now approximately 2:19 p.m. We are now going back on the record.
Good afternoon, Mr. Martin.
Good afternoon, Mr. Shea.
I'm going to resume my questioning where we left off before the break with paragraph 24 of your complaint and the July 21st, 2004 broadcast.
2014, I think.
2014, I'm sorry. Now, once again, that's an excerpt from the transcript of the broadcast. And you would acknowledge it's not the complete transcript of that broadcast, is it?
Yeah, it's certainly not.
Right. Now, with regard to the statements from that excerpt in the transcript that Mr. Villa made on July 21st, 2014, which of those statements did he make with knowledge that the statement was false?
I would have to say in answer to that, Mr. Shea, that I don't know what his knowledge was. I am contending that he made these statements with reckless disregard of truth or falsity.
Okay, and is that correct with regard to all of the excerpts from the broadcasts that appear in paragraph 24?
So you're asking not just about A, subparagraph A, but you're asking about B, C, D, E?
Yes.
Yes, I would agree.
All right. Now, going back to the July 21st, 2014 excerpt from the transcript, what did Mr. Villa say there that was in reckless disregard of the truth?
I'll answer it again, where he indicates that Jim Martin fixes these cases. He says Jim Martin fixes DUI homicide cases for connected cronies. He accuses me of not collecting evidence, concealing evidence, lying to the grieving family, that Lehigh Valley Hospital screwed up the paperwork, lying to judges. Again, not collecting evidence, concealing evidence, lying, and lying to a judge.
Okay. Going back then to the statement, fixes these cases, what did you interpret that to mean?
I interpreted it, and I think the clear understanding is that I acted improperly and disposed of a case or charged inappropriately in a case in return for some favor of one type or another, whether it was money or gratitude or political, all those things I think are within the common understanding of people, that when someone accuses a district attorney of fixing a case, that there's been some quid pro quo for the action taken by the district attorney.
Can you cite anywhere in any of those transcripts where he said you did something in a criminal case for money?
No, but I think that would be a common understanding, or at least an implication, when someone says he fixes cases.
In fact, during those interviews, he specifically said that he was not accusing you of accepting money or anything in return for your actions in criminal cases.
I'm not aware that he ever stated that. I don't recall that. He accused me of being corrupt.
Okay. And anywhere in those interviews, did he accuse you of a specific crime?
Well, I think if he accuses me of fixing cases, that would be a crime.
And did he say that?
Did he say I committed a crime?
You committed a
I
crime.
don't recall. I don't think so.
And in terms of his claim that you were corrupt, did he make any specific claim of a criminal violation with regard to that?
I don't think he has to. If you say somebody's corrupt, that's defamatory per se.
But corrupt doesn't necessarily have to mean criminal action, does it?
Well, if there was an investigation that found corruption, it would most likely be criminal. If I accepted something in exchange for acting in an inappropriate way in terms of my office, that would be corruption, and I could be prosecuted for it.
Did Mr. Villa, in any of those interviews, accuse you of that, accepting something in return for favors in a prosecution?
No.
The reference to fixes DUI homicide cases for connected cronies, what does that refer to?
I don't know what it refers to. It's not true.
Right, but you read all the interviews, you said, right?
Well, I read what I see in front of me. You're asking me, what does that mean?
Right.
I don't know what Mr. Villa means, because it isn't factually accurate. It isn't true. I don't fix cases, and I have not fixed DUI cases for connected cronies. I don't know what a connected crony is, by the way, but that's his language, not mine.
In anywhere in those WAEB interviews, did he say that you fixed the DUI homicide case for money?
No. I think it's implied.
Did you review the WAEB transcripts to see if Mr. Villa had put that term fixes in context, what he meant by it?
I heard the broadcast. I see what's in the complaint. I put it into context as being defamatory.
But how about him putting it in context? Did he provide a definition for what he meant by fixes?
Not that I'm aware of.
And you did read the transcripts?
A long time ago, Mr. Shea. I don't have a specific recollection of everything that's in the transcripts.
And you took exception to his saying one of the things was not collecting evidence.
I've taken basically exception to everything that's set forth in paragraph 24A.
Right, but I'm talking about not collecting evidence. Do you know what that refers to?
I think that he's referring to the Squires case
And so,
inappropriately and erroneously.
what was erroneous about it?
There was no failure to collect evidence. There was evidence that was apparently misplaced.
And how about concealing evidence? Do you know what that refers to?
I believe that he was referring again to the Squires case, but that's inaccurate, factually incorrect. It's not true. There was no evidence that was concealed.
And the reference to lying to the grieving family, what does that refer to?
I think, again, that's a reference to what Mr. Villa contends was told to the family of Zachary Money, who was the deceased victim in the Squires case.
And the reference to lying to judges. In the context of his WAEB interviews, was he accusing you directly of that or a member of your staff?
Me.
How about a member of your staff?
I think that as well.
And which member of your staff in which case?
Well, if it was the Squires case that he was referring to, it would have been Renee Smith.
And you have, again, read the transcript, so you know what he was referring to.
No, I don't know what he was referring to. I can't get inside Mr. Villa's mind, Mr. Shea.
Malice is a state of mind, isn't it?
Can be.
And in terms of defamation, one of the definitions of malice is that he knew what he was saying was false. But you've already said you can't point to anything to show that he knew what he said was false, correct?
I said that what he has said is false and defamatory, and the statements were made with reckless disregard as to their truth or falsity.
Right, but not knowingly false, because you can't get into his head.
Correct.
Reckless disregard of truth or falsity. What investigation with regard to the matters referred to in that July 21st, 2014 broadcast, what investigation could Mr. Villa have done above and beyond what he describes in that broadcast and the other broadcasts?
Well, Mr. Villa was not in possession of the facts that I was in possession of and couldn't have been.
Okay. All right. So
the statements that he made were without any pretense of knowledge, and therefore were made falsely or in reckless disregard of the truth or falsity of the statements.
now with regard to the case involving his daughter, he certainly had personal knowledge of the facts of that case, didn't he?
No. He wasn't in the car. He wasn't part of the investigation. He was never provided, nor could he be provided, with the investigative information.
So in other words, he had to go on the information that was available to the public in order to make these judgments.
I don't know what he went on.
Well, I think you've already said he could not have gone on any more than what he said because he would not have had access to that information.
I'm saying he had no pretense of knowledge of the many and varied factors that went into the decision in any of these cases, the charging decision or the decision not to charge a specific crime, because he had no personal knowledge of the facts and circumstances of any of these crashes.
And I think as you and your staff have made clear through CREA, not only wouldn't he have had access at that time, but he still doesn't have access, correct?
CREA prohibits us from secondarily disseminating written investigative information.
Right. So when you say it was information he could not have had, are you saying that that was information protected by CREA, which he could not have had access to?
I'm saying that, but I'm also saying he never made any inquiry or any attempt to get that information prior to this lawsuit.
Inquiry from him, from whom?
From him, from Mr. Villa.
I'm sorry, I don't understand that answer.
Well, I'll try to clear it up for you if you
Sure,
want me
please
to.
do so. What else could he have done in terms of his own
Well,
investigation?
I didn't say he could have done anything else. I said he never made any inquiry, any independent inquiry of any persons in my office or any police investigators or any accident reconstructionists or any experts.
Right. And would you have permitted you and your staff to provide that information to him as part of his investigation?
We could not have provided him with any written information because that would have been violative of CREA.
Could you have provided him any oral information?
We could have talked to him and explained our reasoning. And in the one meeting that I had with him with regard to his daughter's case, I attempted to do that.
And you refused his request?
Well, I refused his request to charge murder 3 because in my judgment that would have been inappropriate.
Okay. Moving ahead then to subparagraph B of paragraph 24, the July 22nd, 2014 broadcast. And I don't think I've indicated before, but the subparagraphs here listing the broadcast have certain things in bold print, correct?
Yes.
And the first statement there, Jim Martin's not the only crooked and incompetent DA. And then Bobby Gunther Walsh says, now you're saying he's crooked? Answer, yeah. And then he goes on to explain, and it appears some lines were left out there with the 3 markings. And when I say crooked, that's what I mean. He plays favorites. So he put his definition of crooked in context, right?
Well, do you want to read the rest of it?
I
If you're talking about context, Mr. Shea, he's saying in the Chris Squires case, Jim Martin's longtime friends with the defendant's grandfather.
Okay, I will get to that. All right?
Well, I mean, you're breaking it apart and asking me only a question about half the statement that's there.
And I'm entitled to do that. And your attorney
I'm
can...
entitled to qualify my answer then.
No, you're not. Your attorney does.
All right, fine.
Okay? Now, he then explained what he meant by crooked in those lines that I've read. Is that correct?
Well, in that one instance, he says he plays favorites.
Okay. And then he goes on to cite, in the Chris Squires case, Jim Martin's longtime friends with the defendant's grandfather.
That's an absolutely incorrect statement.
All right. Is there any indication in that statement that Mr. Villa knew that wasn't true?
Well, if Mr. Villa makes a statement indicating that I am longtime friends with somebody who I'm not a longtime friend of or even a friend of, but merely an acquaintance of, I think that's an incorrect statement. I don't know that there's any necessity to show an intent or a knowledge that it was an incorrect statement if it's made recklessly.
All right, so your quarrel is with the use of the term longtime friend as opposed to using the word acquaintance.
No, my quarrel is when I say crooked, that's what I mean. He plays favorites.
Okay.
I mean, I can explain away whatever connection he thinks I have with Chris Squires' grandfather, but,
But you just...
what I object to mostly is the statement, when I say crooked, that's what I mean.
Yeah,
End of sentence.
But my question was about the reference to longtime friends, and you said that that was a false statement.
It is a false statement.
Okay. And your quarrel is with the use of the word friends because you said, in fact, you were an acquaintance of his.
I don't like the use of the term quarrel, Mr. Shea. I will just rest on the statement that Mr. Ned Squires, who is Chris Squires' grandfather, and I are acquainted with one another.
All right. So you don't want to use the word quarrel, but you dispute the use of the term longtime friends. How about if he would have said longtime acquaintances?
Well, I wouldn't have any quarrel, to use your term, with the term longtime acquaintance, but I would still quarrel with the allegation that in resolving Chris Squires' case, I did so because of my acquaintanceship with his grandfather, or that I was crooked.
How were you acquainted with Chris Squires' grandfather?
I was introduced to him at a restaurant, Kern's Restaurant. Mr. Squires and his wife were in the company of friends of mine, Jim and Jane Gallo, both of whom are unfortunately now deceased. But as I recall, the Gallos and the Squires were coming from some event associated with a Catholic church movement called Casilo. I'm not familiar with what that means or what it involves, but I recall that specifically. They were seated at a table. My wife and I were at Kern's, and I was introduced to Ned Squires on that occasion.
And how long ago was that?
Probably 30 years ago,
Okay. And after that,
maybe longer.
After that, did you continue to have an acquaintance with Mr. Squires' grandfather?
Mr. Squire, Ned Squires is his name.
Okay.
He was a lector at St. Catherine of Siena Church, Cathedral Church in Allentown. I would see him when I was a member of that parish. I haven't been a member of that parish since 1988. And I would only see him on occasion. If I happened to go to the Mass that he was a lector at, I might see him and not have any conversation or interaction with him. I saw him once at Seward's restaurant in Allentown when he was in the company of, and I think this was before the crash that was the subject of the prosecution, where I met him in the company of some of his children or grandchildren, I'm not sure which. I met he and his wife at an event that the Bar Association held in 2007, commemorating the installation of Judges James Anthony and Michelle Verricchio, which Mr. Villa mischaracterizes and has in his blog, and I think maybe on his radio broadcast, as some sort of an election victory party for myself. It had nothing to do with me. It was a Bar Association sponsored event that Ned Squires and his wife were present at. The last time I saw Ned Squires was several years ago, and I went into a liquor store at the Promenade Shops around Christmas time, and he was pouring out complimentary tastings of wine.
All right. And this acquaintance with Ned Squires was still, for lack of a better term, in existence when his grandson was charged. Is that correct?
My acquaintanceship with Mr. Squires dates back to when I said, which I estimated was about 30 years ago. So, yeah, I was acquainted with Ned Squires at the time of the case involving his grandson. But my acquaintance was limited to a handful of times that I was ever in his presence.
Right.
I don't know where he lives. I don't know who his wife is, or I don't know her name anyway. He's never been a visitor to my home. I've never been to his home. I know very little about the man, other than I was introduced to him.
But you knew him.
Yes, I knew him.
And at the time of the criminal proceedings against his grandson, were you aware that Ned Squires was the grandfather of the man being charged?
I think I developed an awareness of that at some point, but I don't know that I was aware of it when I first heard about the crash. It's kind of an unusual name. I think I may have asked.
Is there anything in the district attorney's office like a conflict check in private practice to see if there's a problem with the district attorney's office bringing a prosecution
No,
against an individual defendant?
No, there's nothing like that other than my own knowledge and the knowledge of any of my assistants. If that occurs under the Commonwealth Attorneys Act, I am required, at least ethically required, I don't think the Act requires me to do it, but I have the option under those circumstances of referring the matter to the Attorney General of the Commonwealth for prosecution or investigation.
Did you consider doing that here?
No.
Like, Going back to the July 22nd, 2014 broadcast excerpt in paragraph 24B, there's a statement, the district attorney's office lied and blamed erroneously Lehigh Valley Hospital with screwing up the paperwork on the chain of custody of the blood evidence and used that as excuse to the grieving family the night before trial for the reason to have to drop the charges. A very dirty pool. So what does that statement refer to your knowledge?
It refers erroneously and inaccurately to a situation that developed after the jury was selected in an in-chambers conference between Renee Smith and Glenn Clark, who was representing Mr. Squires, and Judge Steinberg about some evidence that in the Squires case, there were supposedly 2 tubes of blood drawn at the hospital. One tube referred to as a medical blood draw, which the physicians treating Mr. Squires would have been using, and the other tube of blood related to a, quote, legal, close quote, blood draw. There was no evidence of what happened to the legal tube of blood, and it was contemplated by Renee Smith that she would introduce into evidence the blood testing results that pertain to the medical blood. When you do that, and it's done with, I don't want to say with frequency, but on occasion, where all we have are medical blood draws, there has to be a conversion. The medical blood is 10 to 30% higher in concentration than whole blood, which is drawn as a, quote, legal, unquote, blood draw. It was related to me by Renee Smith that one of the problems that developed in that conference after the jury was selected was that Judge Steinberg indicated that he wasn't sure he was going to let the medical blood results into evidence because we had no explanation for what happened to the legal blood draw. We didn't know what happened to the legal blood draw. But I have no knowledge, nor do I believe it's a true statement to say that we either lied to the family about that blood evidence or lied to the judge about that blood evidence. That was one factor in that pretrial conference that caused Renee Smith to decide to drop the one charge of homicide by vehicle while DUI. There were other factors as well.
Were you involved in that discussion? Were you present when it was taking place?
No, it was brought to my attention by Renee Smith after the discussion took place.
Right. And did Renee Smith indicate she had had discussions with the victim's family?
She had discussions. She didn't indicate to me that she had had discussions with the victim's family in the context of what took place in the pretrial conference, I call it a pretrial conference, but it occurred after the jury was selected. She did later have a conference with the family that evening to explain that the case had changed from a trial to a plea.
Did she give any indication to you whether the victim's family agreed to the plea arrangement?
She indicated to me that the victim's family was understanding and in agreement, and that, in fact, Mr. Money did not want to see Mr. Squires go to jail.
Did you...
Or at least not go to jail for a protracted period of time.
Now, everything that you're telling me is all based upon your conversations with Renee Smith, correct?
Correct.
You were not present for the court proceedings. You were not involved in the plea discussions, and you were not involved with speaking with the victim's family. Am I correct about that?
Well, you're correct, but I want to qualify. When you talk about plea discussions, Renee Smith brought to my attention what had occurred and sought my approval to drop the homicide by vehicle while DUI charge.
Right. And you gave that approval?
Yes.
Right. Was there any other evidence of DUI of the defendant other than this blood sample, which you say could not be utilized?
No, and in fact, first of all, Mr. Squires was under the age of 21. He was a minor for purposes of driving under the influence. So driving under the influence could have been proven with as little or as low a BAC as 0.02%. Based on the medical blood and the conversion, a technician a technician from the laboratory would have testified that his BAC would have been between a 0.07% and a 0.09%. Driving under the influence for purposes of BAC is 0.08%. So we could have, and he did plead guilty to DUI on the basis that he was a minor and that he had greater than 0.02% BAC, but we likely, there would have been a reasonable doubt as to whether or not he was impaired because of the presumed, and the defense had an expert who was prepared to come in and testify that with the conversion, his blood alcohol content was 0.07% and that he was not impaired as a result thereby.
Okay, I think my question was there any other evidence that the defendant was drinking other than that blood sample evidence?
I don't know. I mean, there were three people in the vehicle. Zachary Money, of course, was killed. The vehicle was actually owned by a Kyle Gawker, who was also a passenger. When I say, I shouldn't say owned. It was his vehicle. Whether it was owned by him or owned by his parents, I don't know. As I sit here, but Gawker, I don't know whether Gawker said anything about whether Chris Squires was drinking or whether he was drinking at night. I don't know. You're asking about other evidence of drinking. That's my best recollection.
All right. Was there any other evidence of drinking, such as the investigating officer smelling alcohol in the breath of the
Investigating
defendant?
officers were not at the accident scene that I'm aware of. I think the first encounter with Mr. Squires was in the hospital.
All right. And was any investigation done of the surviving passenger in the car with
Yeah.
regard to?
I mean, he was talked with. He turned out not to be very credible.
Generally speaking, issues of credibility are what we entrust a jury to do.
No, well, generally speaking, Mr. Shea, if I'm to make a charging decision or make a decision on the basis of information that's given to me about whether or not we should enter into a plea agreement, I'm going to take a crack at judging a person's credibility.
Rather than leave that to the jury to determine.
Well, it may or may not be left to the jury. If I conclude that the evidence, because of a lack of credibility, is insufficient to prove beyond a reasonable doubt the guilt of the defendant, I'm going to proceed on that basis.
And in this case, that's what you did rather than continue on with the trial for the...
Mr. Shea, there was another factor. Do you want me to tell you the other factor or not?
Sure, go ahead.
Okay. The 911 call that came in to the comm center, the person identified himself as Chris Squires. His voice appeared to be slurred on that call, and he indicated that he was driving a vehicle which had just crashed. On the eve of trial, and in the pretrial conference with Judge Steinberg, we were told for the first time that that call was not made by Chris Squires, but was made by Kyle Gawker. Kyle Gawker was the only person at that time who could prove that Squires was driving his vehicle, Gawker's vehicle. So that raises a question of credibility. Why would Kyle Gawker call an accident to a 911 center, identify himself as Chris Squires, and say he was the driver of the car? We couldn't prove at that point that Chris Squires was driving because there wasn't any police presence at the accident scene.
And all of the...
And no witnesses other than Gawker.
Okay. This information that you've just described, was that something you found out independently or something that Renee Smith told you?
It's what Renee Smith told me.
Right. Is there any way that Mr. Villa could have had access to that information?
I don't know whether, I believe that that Renee Smith may have expressed that as being one of the problems to the Money family that caused us to drop the homicide by vehicle while DUI charge. And perhaps, I believe Mr. Villa has indicated that he was in contact with Zachary Money's father. And I don't know, I'm surmising that it's possible that Mr. Money conveyed that information to Mr. Villa.
But you don't know that for a
I
fact.
said I don't know.
Okay. By the way, did Mr. Money ever have any second thoughts that you became aware of with regard to that plea arrangement?
Not that I'm aware of.
Now, moving then to subparagraph C of paragraph 24, the June 16th, 2014 broadcast, and there's a very brief excerpt from that broadcast, which includes the highlighted statement, the district attorney's office, Jim Martin, there's a culture of corruption and incompetence and laziness going on there. Incompetence, you would certainly disagree with that description, correct?
Yes,
But that's an opinion, isn't it?
I suppose. It's not predicated on any fact.
But even if it's predicated on fact, calling someone incompetent is an opinion, isn't it?
It may be an opinion, but in my opinion, it's defamatory.
Okay, so it's your opinion versus Mr. Villa's opinion.
Yes.
All right. And laziness. Is laziness defamatory?
I think it could be in the context of a district attorney in his office, sure.
Well, once again, that's an opinion, isn't it?
I have just objection. You know my objection. We're having a legal argument here. You can continue with these questions. And
Laziness is an opinion, isn't it?
An unwarranted opinion in this instance.
You don't think you're lazy?
No, I don't think I'm lazy. I work damn hard, Mr.
All right, so it's
Chair.
it's your opinion versus Mr. Villa's opinion on the question of your being lazy.
Well, the laziness is also attributed to the entire office, I believe. When he says, the district attorney's office, Jim Martin, there's a culture of corruption and incompetence and laziness. So it's attributed not just to me, but to my office.
And that's
the people who comprise that office.
right, and that's true of a lot of Mr. Villa's statements in the WAEB interviews. They were not just about you as DA, but as your staff and the performance of their duties under your supervision, correct?
I'm not going to agree that that's true of a lot of his statements. His statements were primarily targeting me.
But you've also just indicated,
In one instance, yes.
certainly with regard to this instance, that it applied to your office as well.
Correct.
Were there other instances in the interviews where he did that?
There may have been. I don't recall off the top of my head.
Now, continuing on with the June 16, 2014 broadcast, with regard to where Mr. Walsh says, those are pretty strong words, though, to say corruption.
I agree with Mr. Walsh.
Okay. Mr. Villa states, yeah, I would say yeah. Well, there was certainly favoritism in the case where my daughter was killed. Mr. Villa certainly believed that to be true, didn't he?
I don't know.
Do you
He
have
said it. I don't know whether he believed it.
Do you have any evidence that that he did not believe that that was true?
The evidence I have is that there was no favoritism shown, and therefore, how could he believe it to be true?
Do you know what his charge of favoritism referred to?
Well, initially, I think he was referring to the fact that charges against Robert Labar had not been brought within a 5-week period from the happening of the crash that killed his daughter, Sheena. He accused me in the very first email that I alluded to earlier of showing favoritism because Robert Labar was the son of an Allentown lawyer, Donald Labar.
Okay, we will get into that shortly. But his statement that Robert Labar was a son of Allentown attorney Donald Labar, that's true.
It is true.
Okay, moving on then to subparagraph D of 24, May 29, 2014 broadcast. Again, there's a highlighting from that excerpt. Definitely a culture of corruption and incompetence that permeates the office of Lehigh County District Attorney Jim Martin. And we've already gone through that in regard to some of the other transcripts of the interviews. Mr. Villa then goes on to explain, and that is included in the excerpt, I would like to see people charged with and convicted of the crimes they commit. And in Lehigh County, with drunk drivers, comma, that rarely happens, thanks to Jim Martin. What about that statement indicates to you, if anything, that Mr. Villa did not believe that to be true?
Once again, Mr. Shea, I am unable to answer anything about what Mr. Villa believes. I can only tell you that it is factually inaccurate. We prosecute about 1,200 drunk drivers, maybe more drunk drivers in a year, and have for the 23 years that I've been district attorney. So to say that with drunk drivers that rarely happens thanks to Jim Martin is completely false and idiotic.
It's an expression of an opinion, though, isn't it?
No, I think it's an expression of what he is putting out there as fact.
And in support of that statement, he has cited the criminal cases that we've already gone over, correct? And he did that throughout the interviews, correct?
Well, you're focusing on May 29, and in the complaint, there's nothing in May 29's broadcast that relates back to the cases that are cited in the paragraph A of that paragraph of the complaint, which relates to an interview of Mr. Villa on July 21st.
How about the rest of the transcript from that broadcast, other than the 1, 2, 3, 4, 5, 6, 7 lines quoted there?
Which paragraph or subparagraph are you on?
Subparagraph D.
D as in dog.
D as in dog, May 29, 2014.
Well, I see 4 paragraphs. You said 7, I think.
I was counting the number of, did I say paragraphs? I meant lines.
I would agree that there are 7 lines.
How about the rest of that transcript for that broadcast?
I don't recall what the rest of the transcript says.
Anything else that he cited in support of those claims?
I just indicated, I don't know what else was said during that particular interview, Mr. Shea.
Now moving on to subparagraph E of 24, the February 24th, 2014 transcript. And again, there's excerpts from that interview on that date. And Mr. Villa states, and this has been highlighted, Jim Martin arranged in secret a bargain plea deal with Sheena's killer and his family. Do you know what Mr. Villa was referring to?
I assume, I'm not going to assume anything. I don't know what he was referring to.
Any reason, or do you have any evidence that Mr. Villa, when he said that, did not believe it to be true?
Well, Mr. Villa was kept informed of the progress of the case involving the death of his daughter throughout. He was, as I indicated earlier, his attention was brought to the fact that there would be a guilty plea, subsequently a sentencing. In point of fact, when he says a bargained plea deal, as I think I've explained earlier, the plea agreement was only to the extent that some summary offenses, and I think the offense of involuntary manslaughter, were withdrawn, which is quite common, and involuntary manslaughter would have merged with the homicide by vehicle in any case, I think. So,
in any event, putting that comment into context, it was also made at a time when Mr. Villa expressed both to you previously and during these interviews that he felt that Mr. Labar should have been charged with third-degree murder, correct?
Mr. Shea, the statement that you're asking me to comment on was made on February 24, 2014, some 7 years after Mr. Labar's guilty plea and sentence. So I don't understand the question. I can't respond to it the way it's framed.
All right. In any event, Mr. Villa was of the opinion and strongly urged you to have Mr. Labar charged with third-degree murder.
Yes, both before and after the charges were filed.
Now, with regard to being notified about the guilty plea hearing, Mr. Villa has said in those interviews that he was not invited.
Well, I think the information I have is that Mr. Villa was on notice of the entry of the guilty plea or the prospective entry of a guilty plea, and he was in fact in court for the entry of that guilty plea. Right. He was also in court for the sentencing of Mr. Labar. I am not aware of any effort to preclude Mr. Villa from finding out about that. Quite the contrary, we would have, under the Victims' Bill of Rights, we would have an obligation to inform the surviving victims, and so far as I know, that was done. And there certainly was no secret bargain plea deal.
And once again, I think you've testified to this earlier. You had no personal involvement in terms of sending out the notices or the invitation or anything like that. That was done by another member of your staff.
It's not an invitation, Mr. Shea.
Well, what is it?
It's a notice.
Okay.
Okay.
Do you have any personal knowledge
I don't.
That the notice was sent out?
No.
And then the final statement from Mr. Villa contained in 24. I believe that's E, the February 24, 2014 broadcast. The excerpt says, "I've been watching the district attorney's office and the local media and seeing how they collude to conceal the truth." What does that refer to?
I don't know. I can tell you what I think it refers to, which is the Squires case, given the context of what appears in the paragraphs above that statement.
And I think we learned this 2015, 2016 and on. Collusion is not a crime, is it?
Just objection
Okay.
To the form. But if you can answer, you can answer.
I think collusion can be a crime.
It can be, but is there a crime called collusion?
No, not in the Pennsylvania Crimes Code. There are crimes that are akin to collusion.
Like conspiracy to commit a crime?
Well, I wouldn't say that's collusion, but it's conspiracy, yeah.
Right. What does a conspiracy require?
An agreement between two people to commit a crime.
Okay.
The judge who taught me criminal procedure, criminal law, said it was like two people breathing together.
Now, in paragraph 34, you make allegations concerning blog and Facebook site postings by Mr. Villa, correct?
Yes.
And in that paragraph, you then list subparagraphs A, B, and C describing the statements in Mr. Villa's blog and Facebook site supporting your claim for defamation, correct?
Yes.
Sub A, we can dethrone crooked and incompetent Lehigh County District Attorney Jim Martin. Now, you've already testified about crooked and incompetent. When he uses the term dethrone, he meant to say that he intended to have you defeated,
Is that a question?
to be defeated in any election to be reelected as district attorney.
I don't know what Mr. Villa means by dethrone.
You're not a king, are you?
No.
All right. And
My wife would tell you that.
Right. And the position you held was as district attorney.
Correct.
Right. So if you were going to dethrone the district attorney, you would fight his reelection, correct?
I suppose that's true, Mr. Shea.
Right. Paragraph 37 of the complaint. You refer to the program of April 10th, 2014, referring to crookedness and incompetence in the prosecution of cases by the Lehigh County District Attorney's Office. And you set forth an exchanger between Mr. Walsh and Mr. Villa. What about that particular exchange was defamatory?
Well, Mr. Villa is asked by Mr. Walsh, well, you thought it was crooked because you have said there's dots to connect, Mr. Villa, right, Mr. Walsh, which we have connected in the past. So he's referring to the earlier broadcasts interview where Mr. Villa alleges that I'm crooked or that there's corruption or incompetence in the office of district attorney.
Right. Now, in that particular quote there, the word crooked was from Mr. Walsh, correct?
Correct.
Anything in those lines which was said that was defamatory by Mr. Villa?
Well, Mr. Villa is agreeing with Mr. Walsh that Mr. Walsh is recapping what Mr. Villa had previously said.
Okay. But is there anything specifically in those lines that Mr. Villa said that was defamatory?
All Mr. Villa said in those lines is right. So he agreed with Mr. Walsh's characterization.
Then in paragraph 38, of your complaint, you describe in the excerpt, once again, Mr. Villa's statements and Mr. Walsh's statement. And what was the defamation in that excerpt?
Mr. Villa says there is definitely a culture of corruption and incompetence that permeates the office of Lehigh County District Attorney Jim Martin. And then he goes on to say that he can give examples.
And Mr. Walsh says, oh, I know, yeah, you have in the past.
Yeah, right.
What examples are being referred to there?
Whatever he said in connection with the cases that he's referred to in those earlier broadcasts and maybe this broadcast. But, Mr. Shea, when you say, as Mr. Villa did repeatedly, that there's a culture of corruption and incompetence that permeates the office of Lehigh County District Attorney, you're not just accusing me of being corrupt and incompetent, you're accusing the people who work for me. I'm the captain of that ship, and any accusation that the assistant district attorneys or anyone who works in my office being corrupt or incompetent reflects on me as the leader of the office.
Are you filing, or have you filed this lawsuit and are proceeding with this lawsuit, not only for your own personal interest, but for the interests of your staff?
No. just only for my own personal interest.
But in doing so, you're attempting to protect accusations against your staff?
No, I only indicated that an accusation of corruption and incompetence against the district attorney's office, when it said that it permeates the office, reflects on me and is defamatory of me as the leader and captain of the office.
Mr. Villa, in his radio interviews, criticized not just you, but members of your staff in the handling of the specific cases, correct?
I think the only person on my staff who he criticized directly or by name was Renee Smith.
Okay, paragraph 45 of your complaint. You state, defendants intentionally and/or recklessly failed to investigate their statements and implications about Martin before making them, and published the false, malicious, and defamatory statements and innuendo about Martin with a knowledge of their falsity or a reckless disregard for their truth or falsity. Now, in that paragraph, you're referring not just to Mr. Villa, but Bobby Gunther Walsh and the WAEB defendants, correct?
Correct.
Right. With regard to Mr. Villa, what did he recklessly fail to investigate?
Everything.
All right, you have to be more specific than everything.
You asked me, I said everything.
Okay.
That's as specific as I can be.
All right, you can't be more specific than that.
I'm saying that all the allegations that he made that we are saying were defamatory were not based on any actual fact, and that he didn't do any investigation. He never queried me about any of these other cases.
All right.
He never queried anyone, to my knowledge, about any of these other cases other than in the instance of the Money family, and I think with respect to Amber Washko, the mother of Joseph Hennessy, Bonnie Brader.
All right, so what additional investigation should he have done?
Well, if he were going to make statements alleging corruption, alleging incompetence, I would think that he might want to talk to me about that. And perhaps ask me what the basis of my decisions were in not charging homicide by vehicle while DUI in connection with the Amber Washko situation and in connection with the Jennifer Gariner situation. I would have explained it to him.
You would have.
Sure.
All right. Just the way you explained to him that you were not going to charge Mr. Labar with third-degree murder.
I'm not going to respond to the question the way that's phrased, Mr. Shea. Just the way? No. I explained to Mr. Villa why I was not going to charge Mr. Labar with murder 3. I would have explained to him, had he asked, why I wasn't going to charge Jennifer Gariner with homicide by vehicle while DUI, and I would have made the same explanation to him with regard to Amber Washko.
Are you telling us that if Mr. Villa had made those requests to meet with you to discuss criminal cases in which he was not involved, you would have granted him an interview and sat down in your office and explained them to him?
If he told me that he was going to go on the radio and defame me if I didn't meet with him, sure.
Okay, all right. If he didn't tell you that,
I might have.
you might have.
Yeah.
All right. You think that's credible, that you might have?
No, don't. Stop. Michael, stop.
Okay. All right, so what else should Mr. Villa have done besides asking you for appointments to discuss these other criminal cases?
Well, I think Mr. Villa and the WAEB defendants and Bobby Gunther Walsh, before they put him on the air, should have at least made some attempt at an independent investigation to verify what Mr. Villa was saying was fact, when in fact it wasn't fact.
Since you listened to the WAEB interviews, you were aware that several times an invitation was extended to you to appear on that program and discuss your viewpoint. You were aware of that, correct?
I am aware of one instance, I think, where Bobby Gunther Walsh made a statement to that effect, yes.
Only one.
One is all I can remember at the moment. If you say he made others,
All right.
maybe he did.
You did not accept that invitation, did you?
No, I did not. He was never communicated to me other than a statement over the air.
Which you heard.
Well, I heard some of it, I guess.
All right. But you were aware that you had been invited.
Come on, Mr. Shea. If I was to be invited, he should have called me, written to me, done something. I was never invited. It was a throwaway line in a radio interview.
All right. Did you consider accepting that throwaway line in the radio interview?
Absolutely not.
To appear yourself personally?
No, I did not.
And explain?
No, I did not.
All right. And why didn't you do that?
Because it was clear to me at that point that both Mr. Villa and Mr. Walsh had an agenda, and that I wasn't going to be able to get any kind of a fair hearing or make any kind of a reasoned response in a few minutes allotted to me on a radio program.
So you permitted the broadcast to go on allegedly defaming you?
I didn't permit anything to go on.
Right.
I had no say in them going on, and I in fact engaged counsel, as you know, and filed this lawsuit.
Did you ever give WAEB and Mr. Villa the opportunity to retract their statements?
I believe my counsel did. I don't know for sure, but I don't know about extending that to Mr. Villa. I believe most of the correspondence, at least early on, was between counsel and the WAEB defendants.
So do you know whether or not Mr. Villa was given the opportunity to retract his
I don't
statements?
know. I would say it was too late.
Let's go off the video for 1 second.
The time is now approximately 3:18 p.m. We are now going off the record. The time is now approximately 3:20 p.m. We are now going back on the record.
All right, getting back to what Mr. Villa could have done in his investigation, other than asking you for an appointment to discuss those other criminal cases, what else could he have done?
I don't know, Mr. Shea. I suppose he could have reached out to the investigating police officers, not suggesting that he necessarily would have gotten any response from them, but he could have made the effort. Could have made the effort to reach out to the assistant district attorneys who were prosecuting those cases.
Anything else?
Not that I can think of. No. God bless you.
Bless you.
Now, with regard to the criminal cases at issue here, other than the case involving Mr. Labar, have you personally reviewed those criminal case files first before the defamation complaint was filed?
I was involved in the charging decisions or the non-charging decisions, whether I wouldn't characterize it as reviewing the files. Typically, my involvement in making those decisions would be in consultation with the assistant district attorney who was charged with the responsibility of prosecuting the case and with the investigating police officers, including perhaps an accident reconstructionist if one was involved.
Before filing the complaint in this defamation action, did you review those criminal case files?
I don't recall. I have pretty good recollection of those cases.
You have a recollection of the cases, but you don't recall if you've examined the files?
I don't recall examining the file in the context of reviewing the files in preparation for filing this complaint, no. I may have and probably did refresh my recollection by talking with the attorneys who were in my office who were involved in those prosecutions,
Okay.
namely Renee Smith, Richard Director, and Paul Bernardino.
And when did you do that?
I did it, certainly at the time the decisions were made. I did it during the course of the broadcast where Mr. Villa was making the defamatory comments about those cases. I did it prior to consulting with my attorneys about the allegations concerning those cases. I mean, I did it recently in preparation for this deposition.
And when you say did it, what did you do?
I talked with the lawyers involved.
Okay, and that's what I want to clarify. You're talking about speaking with the lawyers involved, but I'm talking about reviewing the actual criminal court files.
I didn't do that in connection with the complaint, nor did I do it in connection with preparing for this deposition, except in a very limited extent.
Did you do it at the time that both you and the district attorney's office objected to the production of those records under CREA?
No, because I charged Chief Deputy District Attorney and the Chief of the Appeals Unit in my office, Heather Gallagher, with the responsibility of protecting the integrity of the files and carrying out the duty of the District Attorney's office with respect to CREA, and in fact built a Chinese wall around her and myself in that context.
Right. So make sure I understand the question. I understand the answer. You're saying you did not review those individual criminal court case files to determine yourself what could be produced and not produced under CREA?
I did not.
Did you supervise Heather Gallagher in that process?
No.
Were you aware that she filed objections to the court order requiring the production of those records?
Yes.
And that was a subject of an appeal to the Pennsylvania Superior Court?
Correct.
You filed your own appeal, correct?
My attorneys filed an appeal on behalf of myself independently with
Right.
regard to my duties as district attorney.
And with regard to the appeal by the district attorney's office, you authorized that, correct?
I think that Heather Gallagher determined it on her own initiative that it was something that should be appealed to protect the office in connection with CREA.
So you filed it to protect.
I didn't file it. Heather Gallagher filed it.
Okay, but you did file an appeal through your
my
attorneys.
attorneys, yeah.
Right, to protect yourself with regard to production of those records.
Correct.
And Heather Gallagher, through you as district attorney, also filed an appeal
Not
from the
through me
production
as
of those
district
records.
attorney, acting on her own initiative as chief of appeals, having been vested with the authority by me to take whatever action was necessary to protect the office of district attorney of Lehigh County from a violation of CREA.
Right. Did you have any involvement at all with the district attorney's filings?
I don't understand the question.
Right. Let me make it more clear.
Council is off. It just went off. I don't know if you lost a connection.
Who, Cliff?
Yeah.
Yeah, I don't think you have to worry about that. Let me be more specific. Do you know if your name appeared on the Superior Court brief that Heather Gallagher filed on behalf of the District Attorney's Office?
I think it did, which would be customary.
Customary in most criminal court, Superior Court appeals, correct?
Correct.
But this was not a criminal court case appeal, was it?
Mr. Shea, I mean, let's be real here, okay? My name would appear on any filing that was made from my office as the district attorney. It appears often on civil cases where I'm sued, by criminal defendants for whatever reason, and I assume that if it appeared on, and I believe it did appear on the cover sheet of this appeal, that it was done as a matter of course, probably by some administrative aid and was never noticed or thought about by Heather Gallagher.
You referred a little while ago to the term Chinese wall. Mm-hmm. What did you mean by that?
I meant that Heather Gallagher had the authority to act on behalf of the District Attorney's Office of Lehigh County, independent of seeking any approval from me and independent of having to share any information with me with regard to tactics or anything other than perhaps just keeping me informed nominally about what was going on.
Wouldn't putting your name as district attorney on filings with the Superior Court be a violation of the Chinese wall?
I don't think so.
Why not?
It's just, it's something that is innocuous.
And once again, this was an appeal involving a lawsuit filed by you to recover damages for defamation.
No,
No.
that's not what it was.
It's not?
It was an appeal of, my recollection is that you, it was an appeal of a discovery order based on a motion that you made.
Okay, it wasn't a motion made by me, but maybe I was unclear. But this was an appeal involving the district attorney's office in a private civil matter that you filed for defamation against Bill Villa and the WAEB defendants, correct?
It was an appeal that was filed within the context of that lawsuit, but it was filed for the purpose of protecting investigative information in the hands of the district attorney's office that is prohibited from being secondarily disseminated under the provisions of the Criminal History Record Information Act.
However, once again, the underlying lawsuit involved a private civil action filed by you to recover damages for defamation, correct?
With that qualification, yes.
Need to use the restroom.
Okay.
All right? Take 5 minutes. Sorry.
The time is now approximately 3:30 p.m. We are now going off the record. The time is now approximately 3:40 p.m. We are now going back on the record.
Mr. Martin, I've questioned you about paragraph 22 of the complaint and the specific criminal cases listed there. And we've discussed at length the prosecution of Robert Labar and to some extent the Chris Squires case. I'd like to move on to the Amber Washko case.
Now, let's go off for just 1 second.
The time is now approximately 3:40 p.m. We are now going off the record. The time is now approximately 3:45 p.m. We are now going back on the record.
Mr. Martin, I've had marked as exhibit Martin number 1, a 2-page document entitled Affidavit of Jeffrey Anthony. I believe it was provided through discovery by your counsel and has a Bates stamp designation of Martin 002059 and Martin 002060.
Correct.
Do you recognize that document?
Yes.
You have seen it before.
Yes.
Now, that is a affidavit of Jeffrey Anthony, correct?
Yes.
And who is Jeffrey Anthony?
A man who I believe is a relative of Bill Villa, based on his representation in a phone conversation to me.
When did that phone conversation take place with Jeffrey Anthony?
I think sometime in 2015, shortly after the lawsuit was filed,
And when you took that call, where were you?
in my office.
Had you ever met Jeffrey Anthony before?
Not to my knowledge. He indicated that we had met some years earlier. I have no recollection of meeting him.
And what did he say to you when he called?
He said he wanted to help out in my lawsuit against Bill Villa, and he would like to know the names of my attorneys and a telephone number where he could reach them.
Did he say anything else to you?
He said he'd like to help out in the lawsuit.
And what did you respond?
I gave him the name of Jason Perlman at Sprague & Sprague and his telephone number.
And Jason Perlman was one of the Sprague & Sprague attorneys who handled your case in the beginning, is that correct?
Correct.
And to your knowledge, he is no longer with the firm, correct?
Correct.
Did you have any communications with Jason Perlman about Mr. Anthony and or the affidavit?
Objection. No, don't answer that. That's clearly confidential, attorney-client privilege.
To your knowledge, did Jeffrey Anthony contact your attorneys?
My knowledge, if any, would be predicated on what I was told by my attorney, to which my current attorney objects.
After that initial telephone call with Jeffrey Anthony, did you have any further contacts or communication?
With?
Jeffrey Anthony.
Personally, no, but he's had contact with others in my office.
Who else in your office?
The first assistant district attorney, Stephen Luxa, and the chief of appeals, Heather Gallagher.
And what were those communications about?
Mr. Anthony wants to bring a criminal action against Bill Villa. He had attempted, I think, on several occasions to do that through the Allentown Police Department or other police departments. Through Mr. Luxa and Ms. Gallagher, he was advised that there would be a conflict of interest in prosecuting Mr. Villa. He was advised that if he chose to take that action, he would have to file a private criminal complaint, and it would come into my office for approval, but that I would refer it out to the Attorney General's office because of the conflict that exists by virtue of this lawsuit.
What was that conflict?
The conflict that I'm suing Mr. Villa, and I couldn't prosecute Mr. Villa under those circumstances, nor could I approve a complaint, whether it was a private criminal complaint or a complaint brought by a law enforcement agency.
And why was that? Were there specific rules or regulations, anything you can cite?
Yeah, the ethical rules that govern all lawyers. You know, you're familiar with the conflict of interest rules.
I am, but that's usually, I'll strike that. So you felt, or at least your office felt, that you could not become involved in approving that prosecution, that private criminal complaint by Mr. Anthony against Mr. Villa.
That's correct, and I had previously taken similar action in an earlier private criminal complaint that was filed by a lawyer by the name of Najarian against Mr. Villa.
And we'll get to the involvement of the Attorney General's office later on. But getting back to this affidavit, okay, other than that communication with members of your office about Jeffrey Anthony filing a criminal complaint against Bill Villa, did you have any other involvement with Mr. Anthony after this affidavit was submitted?
Although I think he has attempted to contact me through the telephone, which I've not taken his telephone calls.
And are you aware that he has contacted and written to the judges involved in your case?
I am, by virtue of, I think, an email from Mr. Villa to that effect.
And have you seen any of those letters that Mr. Anthony sent to the court?
No. Well, maybe one. I'm not sure.
Right. Have you taken any individual action to stop Mr. Anthony from communicating with the court?
No, I wish he wouldn't, but...
Right. You would
No.
agree. You would agree that is improper on his part.
Yeah, of course. It's also improper on Mr. Villa's part, who communicates with the court and everybody else in the world, too.
Has he communicated with the court on your case?
Mr.
The case you
Villa?
filed against him, yeah, Mr. Villa.
I don't think so, no.
Okay. When did you first see this affidavit?
At or about the time that it was executed, January 22nd, 2016.
Now, in that affidavit, Mr. Anthony makes statements about speaking with Craig Stevens. And it is his understanding that Mr. Stevens is the Senior Vice President of Programming at WAEB. Were you acquainted with Mr. Stevens before this affidavit?
Not to my knowledge. I mean, I knew that a Craig Stevens existed. I knew he had a position at WAEB, but I don't know Craig Stevens, and I never had any contact, to my knowledge, with Craig Stevens.
Do you have any knowledge about his involvement with having Mr. Villa appear on the Bobby Gunther Walsh radio show?
I know that Mr. Villa has on his blog references to statements that he said Mr. Stevens made, that he'd have him back on the radio soon. That's all.
Have you personally talked with Mr. Stevens about those WAEB interviews?
No,
And I note that you did not name him as a defendant in this defamation action, correct?
correct.
Now, Mr. Anthony goes on in that affidavit to discuss his telephone conversations with Mr. Stevens. In paragraph 5, he said, "I called Mr. Stevens regarding my request that I and others from Mr. Villa's, quote, foes list, end of quote, be given an opportunity to discuss and rebut Mr. Villa's ongoing public accusations against us on his blog." Do you know what the reference is to foes list?
Well, I know that there is a list of people that Mr. Villa has listed as being, pro-Jim Martin, contributors to Jim Martin's campaign. Other people that he alleges are either sympathetic to me or, I've heard it referred to as a foes list only here.
Okay. In any event, in that paragraph 5, Mr. Anthony is stating that he wants to have an opportunity to discuss and rebut Mr. Villa's ongoing public accusations against us. That would be the foes list, would it not?
Well, just objection.
know.
You're asking them to speculate, but
Right.
if you know.
In paragraph 5, is there any mention of your lawsuit against Mr. Villa and any facts that Mr. Anthony might have relevant to that lawsuit?
I don't see anything.
And moving on to the next page, the affidavit states, "In response to my request, Mr. Stevens told me, quote, 'We're not touching it. There's a lawsuit,' end of quote." That would appear to be a reference to the lawsuit that you have filed for this defamation action, correct?
I would assume so.
All right. I think
I
would,
don't like to assume.
I would also like to assume that, but if you want to use a different word, certainly that's a reasonable inference in terms
I'll
of
agree
the
with
reference to
I'll
lawsuit.
agree with the reasonable
Okay.
inference.
And then in 7 of the affidavit, it states, referring to the 11 appearances that Villa made on WAEB, Mr. Stevens told me, quote, "It was a personal vendetta by Villa," end of quote. I understand that Mr. Stevens was referring to Mr. Villa's vendetta against Jim Martin. The vendetta by Villa, personal vendetta. It appears that that's a term you also used in your complaint. Am I correct?
I don't recall.
All right.
I don't disagree with it.
Okay. Mr. Anthony then continues in his affidavit to give further information about his discussion with Mr. Stevens. Mr. Stevens further told me regarding Mr. Villa that, quote, "We are not happy with him," end of quote. Did you ever have any discussions with Mr. Stevens, Bobby Gunther Walsh, or anyone else in the WAEB broadcast entity about WAEB not being happy with Mr. Villa?
No. It's not my affidavit.
Right. And in paragraph 9, the affidavit goes on to state, Mr. Stevens further told me that Mr. Villa misrepresented and that he was using WAEB's logo on his website. Do you have any knowledge about that?
I don't have any knowledge of what Mr. Stevens told Mr. Anthony or anything about a misrepresentation. I believe that WAEB's logo is in fact on Mr. Villa's blog because there's a photograph of Mr. Villa and Bobby Gunther Walsh in the area of the blog where Mr. Villa continues to publish the 11 interviews. I think that there's a logo of WAEB on that photograph, or at least some reference to the WAEB on the photograph.
Okay. And is that of any relevance to the issues in this defamation action?
What?
The use by Mr. Villa of WAEB's logo on his website?
Well, it doesn't affect me, but the continued publication of the interviews on Mr. Villa's blog is, I think, part of this lawsuit, and the fact that he's continuing to defame me and has for every day for the last, 5 years.
Yeah, but I'm talking about the use of the WAEB's logo on his website.
I have no concern about the WAEB logo,
Right.
nor any interest in it.
Then paragraph 10 of the affidavit, Mr. Anthony states, Mr. Stevens also told me that my story, quote, wasn't news anymore, and that, quote, nobody is going to take your story. Nobody cares. They don't need the aggravation, end of quote. I don't see any reference in that statement to you or your lawsuit. Am I correct about that?
You're correct as far as the statement itself. It doesn't say anything about my lawsuit or me.
And in paragraph 11, he states, Mr. Stevens further told me, requiring Mr. Villa that, quote, nobody reads his blog anymore. He writes all the comments himself, end of quote. With regard to his writing all the comments himself, do you have any personal knowledge about that?
I have no personal knowledge about it, no.
And again, I don't see any reference to you, to your lawsuit, or assisting you in your lawsuit in that paragraph from Mr. Anthony. Am I correct about that?
Well, you're correct in terms of the wording of the paragraph. Whether it was meant by Mr. Anthony to be of some assistance in my lawsuit, I don't know. There's no specific reference to that. But I think that the fact that Mr. Anthony talked to my counsel and gave this affidavit was all in an attempt, as expressed by him, to, quote, help me in my lawsuit.
Okay. In paragraph 12, he states, I told Mr. Stevens that, quote, we don't have a vendetta. We just want to get on air and tell our story. If we don't have a vendetta and he did, why did you put him on the air? End of quote. Again, I see no reference to you or supporting you in your lawsuit or assisting you in this lawsuit. Am I correct about that?
The language of the affidavit speaks for itself, Mr. Shea.
I know, but was this being helpful to you?
I don't particularly see it as being helpful.
And then paragraph 13, he states, Stevens responded that, quote, we felt sorry for him. He lost his daughter, end of quote. All right, Mr. Martin, in looking at this affidavit, and correct me if I'm wrong, is there anything in this affidavit that's helpful to you in this case?
Just objection to the form, and that it calls for a legal conclusion, but he can answer.
I suppose that some of it could be interpreted, Mr. Shea, as being helpful to me in this case as it relates to WAEB and Bobby Gunther Walsh.
Okay, that's fair enough.
And I should amend that to include all the WAEB-related defendants.
Understandable.
Okay.
Now, and we'll get to this later on, but you have settled this case against WAEB, correct?
Correct.
With regard to this affidavit in pursuing the case against Bill Villa, is there anything in the affidavit that's helpful to you in proving your case now against Bill Villa only?
I'd have to leave that up to my counsel and be guided by their advice. I mean, yeah, I suppose that the fact that a first cousin of Mr. Villa's is taking a position against Mr. Villa in a lawsuit filed by me might be construed to be helpful. I don't know. It would be up to a jury to interpret it if they ever saw this affidavit or heard Mr. Anthony's testimony.
Well, you've given multiple legal opinions during this deposition. Is there anything in here that's relevant to your case against Mr. Villa?
Objection to the extent it calls for a legal conclusion or a determination as to what is relevant and what is not relevant in this lawsuit, but you can answer.
I've just tried to answer to the best of my ability, Mr. Shea. The dynamics of a jury trial, as you and I both know, take strange turns, and I think that it might be impressive to a jury if there was anything that was admissible that Jeffrey Anthony could offer in this case, that it might have an impact. Some of the things that he's said here, I will acknowledge, pertain mostly to WAEB and those defendants, and not necessarily to Mr. Villa.
Now, you've referred to Jeffrey Anthony being a second cousin, and that's of Mr.
I
Villa?
think I referred to him as being a first cousin based on the affidavit, paragraph 2.
Okay.
He swears Bill Villa is my first cousin on my
Okay.
mother's side of the family. I don't know that, but that's what he says, and swore to.
Now, other than the information contained in this affidavit, do you have any information about Jeffrey Anthony's involvement with the WAEB interviews?
I have information that Mr. Anthony and another cousin of his, James A. Anthony, who's a judge in the Court of Common Pleas of Lehigh County, met over lunch with Bobby Gunther Walsh and Bill Villa, and I know that by virtue of emails that were provided in discovery.
Did you know that before you filed the lawsuit?
I don't think so.
And what, if any, information do you have about Jeffrey Anthony's participation in those meetings and the preparation for the WAEB interviews?
Done?
Now, you've mentioned Judge Anthony. And who is Judge Anthony?
James A. Anthony, no, James T. Anthony, sorry, I misspoke earlier, who is a judge in the Court of Common Pleas of Lehigh County. Has been since 2007. Previously worked for me.
And how would you describe your relationship with Judge Anthony?
Fractured.
And what do you mean by the term fractured?
Well, I think we've probably overcome some of the issues, but Judge Anthony, and I don't know how this is relevant, frankly, but Judge Anthony has reinvented history over the years. He's contended that I promised him the position of First Assistant District Attorney, which is not true and was never true. There was a time when I was considering appointing him as First Assistant after Michael McIntyre left the office. Up until that time, the position of First Assistant had always been part-time. Mr. Anthony wanted the position. I would have been prepared to give it to him at that time, but for the fact that he said he couldn't take it without getting a salary of $100,000, which was completely out of the question, given the budgetary constraints that are imposed on me by Lehigh County. I was creating a full-time position that I think when it was created and ultimately taken by Maria Dantos, who went on to become a judge of Lehigh County, paid approximately $60,000 full-time. That's one reason.
Any
There's
other?
some other reasons.
What other?
that aren't really relevant to this.
I don't see the relevance in going down this path.
Let's
So-
let's go off the record.
The time is now approximately 4:07 p.m. We are now going off the record. The time is now approximately 4:11 p.m. We are now going back on the record.
I have attempted to question Mr. Martin about a potential witness in this case, Judge James Anthony. His attorney has instructed him not to answer the questions because he says the information is not relevant. I don't believe that's a proper basis for an objection, instructing a client not to answer. But in view of the fact that he has instructed Mr. Martin not to answer, I am concluding the deposition, and we will resume a week from today.
Our previous discussion was on the record.
On the written record.
Okay, that's fine. Then I have nothing further to say. My objection's on the record. No.
No, I'm just asking a question. Are these yours or yours?
The exhibit should go to the court.
I gave the
court
exhibit
report.
back to the
Okay.
court.
Marked exhibit should go to her.
Those were just for your use, they're not exhibits.
The time is now approximately 4:12 p.m. We are now going off the record. This concludes the deposition.